Okay, I believe we are ready to begin our second hearing. I'm Judge Thomas E. Malone. We also have on this panel Senior Judge Patrick McEnany and Senior Judge James Burgess. We're conducting this hearing today by Zoom, which we are doing these days under our court's special COVID-19 rules. I'd like to thank the attorneys for your cooperation in participating in the hearing in this manner. I'll briefly repeat the preliminary remarks that I made earlier. I remind counsel that we have read your briefs, so we're familiar with the facts of your case and what the issues are. You might keep that in mind as you make your argument this morning. As the presiding judge, I'll be the timekeeper. Each party is given 20 minutes in this case to make your argument. If there's more than one attorney per side that will be arguing, you need to decide in advance how you wish to divide your time. The appellant's attorney should let us know at the beginning of your argument if you wish to reserve any of your time for rebuttal. After the arguments are made this morning, your case will be deemed submitted for decision. And after that, the court will take the case under advisement and get a written decision out to you and your clients just as soon as we possibly can. So with that, I'll call the second case docket this morning. It's from Marshall County. It's number 120868, entitled Colleen Seematter and the estate of Roger Seematter versus Delmer Seematter and Seematter Farms, Inc. This appeal involves a dispute over a family-operated farm in Marshall County. And so first of all, who do we have here for the appellant?
Your Honor, Bernard Irvin of the law firm of Morrison, Frost, Olson, Irvin, and Schartz, appearing on behalf of the plaintiff appellants.
Thank you. And who do we have for the appellee?
Your Honor, Jay Fowler of Holston Siefkin, appearing on behalf of Delmar Seematter and Seematter.
All right, Mr. Irvin, we will begin with you. First of all, do you wish to reserve any time for rebuttal?
Yes, Your Honor, I'd like to reserve 3 minutes for rebuttal.
That is granted, and you may begin when you're ready.
May it please the court, I appreciate the opportunity to present this appeal via Zoom this morning. I'd much rather be there in person, but given everything that's going on, I'm happy to do it via Zoom because this is a very important matter to my clients. There are two main topics that are before the court today, and those are a farming and a business arrangement between the parties to this case. And then the second issue is a house issue. It's my client's personal residence, and I'm going to address them in that order, which is the same order that I have in my brief. So first of all, with regard to the farming issue, the Family Farm Corporation specifically, the issue before the court is whether the court was presented with sufficient admissible evidence to support the plaintiff's claim of promissory estoppel. And I think the background and facts are critical and important in this case. So I'm going to spend a little bit more time on those than I typically would because of that fact. So most of Roger Seematter's life was spent working with his dad on their family farm. Roger did indeed have hobbies that took him outside the farm, but for the most part, he was a typical farmer and worked, countless hours on the family farm in support of both his operation as well as his dad's operation. In 1997, when he was about 36 years old, he married Colleen, who's one of my clients, and they remained married until Roger died of ALS in 2014 on November 11th. Roger, and along with Colleen, filed this suit about 1 month before he died. And I think that's important to remember, that this is Roger's suit, even though he's not with us here today. It was him and Colleen that filed this suit. And I never met Roger, but from everything I can hear about him, he was a hardworking man, very dedicated to his life on the farm. The claims of Roger and Colleen go against the dad and against the corporation for Delmer Seematter, the dad's promise that one day the family farm corporation would belong to Roger. Unfortunately, the district court in this case found that there were insufficient.
Let me interrupt you with a question. How can
Yes,
that
sir.
promise be fulfilled now?
The promise can be fulfilled through payment of monetary damages. The family farm corporation has value in terms of its assets, both land, cattle, etc. And it's that value that would form the basis for some compensation to Roger's estate, as well as Colleen, his wife.
But doesn't that mean that Delmer has to die first? Wasn't that a condition precedent to the granting of this sum of money or his estate or whatever?
Well, that certainly was the expectation. And I don't think anybody contends that Roger was going to receive the family farm corporation before Delmer died. But the fact of the matter is there was 35 years here where they worked together on the family farm corporation. And it's that 35 years course of conduct that provides the basis for this claim. And the value of the corporation is what provides the remedy, for the cause of action.
But until Delmer dies, the promise doesn't go into effect, does it?
That's probably true. But I guess I would also get back to one of the cases that I cite in my brief, which is the Boughton v. Byers case. And it too was a case based upon the claim of promissory estoppel. And in that case, the promisor had not yet died. It was very the same in that case, the promise was that the promisee would receive the property of the corporation, of the family farm corporation, at the death of the promisor. And notwithstanding the fact that the promisor was still alive in that case, the Court of Appeals of Kansas said that summary judgment was not appropriate in that case, and that the case could continue based upon the facts that were presented. So in that case, it didn't matter that the promisor was still alive. They permitted the case to proceed. And I believe that there are similar facts in this case that should permit this case to also proceed. So the district court ruled that summary judgment was appropriate because of insufficient admissible facts. And I certainly disagree with that. I believe that there are some appropriate and admissible facts to support the claim of promissory estoppel. There's this 35-year course of conduct that's indisputable. Innumerable facts about how Roger worked on the farm, how he provided labor. In the early years, it was primarily labor. In the later years, it was not only labor, but it was also management. For example, he had a power of attorney that permitted him to do work through the FSA office on behalf of the corporation for about the last 10 years. So he was not only involved in the labor, he was also involved in the management of the corporation. And in the later years, when Delmar Seematter's health became, not so well, Roger provided even more of the labor to the family farm corporation at that time, even though he only owned personally about 20% of the total assets of the operation. So the corporation owned most of them. Delmar owned some personally, and then Roger owned some, but it was just a very small amount of the overall operation. Yet Roger was doing most of the work in the later years. So for the claim of promissory estoppel to proceed, as you're aware, 3 elements must be met. The first is that a promisor reasonably expects a promisee to act in reliance on the promise. The second is that the promisee in turn reasonably so acts. And the third is that the court's refusal to enforce the promise would countenance a substantial injustice. And it is our position that all three of those elements are met. The court took particular issue with the first element, which is the promise. And on that issue, in the court's ruling, they said, quote, Delmer never had any conversations with Colleen regarding his intentions for the disposition of his property and SFI, and never indicated that he would include Colleen in his will. And I disagree with the court's finding on this particular fact, because there was indeed a conversation that is admissible dealing with this issue. And that's set forth in my brief. It was set forth in the facts to the district court. It was set forth in an affidavit from Colleen, and it was also set forth in her deposition when Mr. Fowler questioned her about it. And the conversation was dealing with the land upon which they lived. So there's a 160-acre tract of land, and the house that Colleen lives in is in the middle of this tract. And believing that they would get the corporation when Delmer died, they wanted to know about the other half interest, which was owned by Delmer personally. And that's of the 160 acres. So they asked him, we're getting the corporation, what's going to happen to your piece of land, to your undivided 1/2 interest of the land? And Delmer represented that Roger was going to get it as well. So this was confirmation that Roger was going to get the corporation as promised by Delmer. And it's not hard to imagine, in addition to that, based upon this course of conduct, a discussion between the parties. Son, one day this will all be yours. The corporation was formed in 1981. And at that time, Roger received 1 share. Now that wasn't very much, but he did receive 1 share. It's also noteworthy that in 1985, Delmer remarried, and there was a premarital agreement between him and his spouse at that time that excluded her from the family farm corporation. It protected Roger's future interest in that family farm corporation. So when you combine all these facts and that course of conduct, we believe that there are sufficient facts to proceed on this claim of promissory estoppel. We also, there was also a claim for quantum merit. This also is an equity claim. The court really gave it short work in its order, and in fact, just simply referenced back to its findings of fact and conclusions of law on the promissory estoppel claim, and really made no specific findings of fact as it relates to this issue. So we believe that the court erred in that regard as well. In addition, if you look at the evidence that was admissible on this claim, there's evidence that Colleen worked for the farm and never received any payment. She did get some health insurance benefits, but that's inadequate under the circumstances, and that was kind of a family perk that Roger also received. And
let me interrupt you with a question. You just have 5 minutes left in your first part, and I'm really interested in the third issue and the homestead issue with the repurchase agreement. Why don't you go ahead and turn to that and make your own?
Absolutely. And so if getting carved out of the family farm wasn't enough, Delmer has also exercised an option to repurchase the house. And this is also very fact driven, but pretty legal in that I also filed a motion for summary judgment, believing that it should be awarded by the court, but the court disagreed. And I think there's one key fact here that I want to talk about in this regard, and that is at Appendix A to my brief, I attached a deed that was presented to Colleen and Roger as they were financing the purchase of this property. And this is an unsigned deed. I'll concede that it was never signed to the best of my knowledge. It was never recorded, but it is exactly the same as the deed that was ultimately recorded, except for the option contract in there providing for the option for Delmer to repurchase the house. And this is the deed that was presented to Colleen. She gave it to the bank and they got financing. And she never was aware of the option from Delmer to repurchase the house until 2014 when Roger was about ready to die. She never agreed to it. And the existence of that first deed is noteworthy in my mind.
Is there any evidence that Roger agreed to the repurchase provision?
The evidence presented to the court was that Delmer testified in his deposition that Roger was aware of the repurchase agreement. Now, Colleen disputes that, but the reality is Roger's not here to tell us. And I think quite frankly, it's conceivable maybe that Roger did know. Maybe Roger knew and he chose not to tell Colleen in an effort to preserve the family peace. He thought, it's never going to come into play. I'm never going to get divorced. I'm 30 years younger than Delmer. I'm going to outlive him. So it's never going to come into play. It's a non-issue. But the reality is it is an issue. It was an issue because we're here talking about it today. So I guess what I believe is that statute of limitations applies to this issue.
Wasn't Colleen, wouldn't she have been on notice of this provision in the deed? Because I assume that the normal practice occurs where after the deed is recorded, it's returned to the grantee, and she and her husband would have received the deed back. Wouldn't that put them on notice of the addition of that reservation of rights?
Yes, there's a statute that provides for notice, as you've just spoken, and that would be the ordinary practices that the deed would go to the grantees. But there's no evidence of what happened to the original deed in this case, and Colleen contends that she doesn't have it and never saw it. And the case.
Another question I have is on the statute of frauds. The statute of frauds says no action shall be brought on any contract for the sale of lands. I assume that's the part you're referring to.
Yes. Yes, Your Honor.
It's always seemed to me that a deed as an instrument of conveyance is not a contract. It's not it's a unilateral grant of an interest in land to a grantee. Does it really satisfy the requirements of being a contract? Particularly here where we don't have an underlying real estate contract.
The provision in there in the deed dealing with the repurchase is under Kansas law an option contract. It is an option is an agreement to buy land in the future, a possible agreement to buy land in the future, if exercised by the person with whom that holds the option. But it's a contract under Kansas law. And a contract to sell real estate under Kansas law has to be in writing, and it has to be signed by the person against whom enforcement is sought.
You don't view this as basically a reservation of certain rights that are not being conveyed, or it's subject to this contingency that gives the grantee less than a fee simple ownership of the property outright?
I think there's a distinction, Your Honor. And the distinction is, in fact, there's a distinction in this deed itself. There's a reservation for a travel easement, which I believe is an appropriate reservation under Kansas law. But there are no Kansas law cases on point on this matter about the meaning of an option contained in a deed. And that's why I've used other case law to support my position here. And in fact, the Illinois case that I cite is exactly on point in that there was a very similar contract option in the deed, and that deed was not signed by the grantees, and the court refused to uphold it under the statute of limitations, saying that this option contract had to meet all of the elements of a real estate contract. And because it was not signed by the grantees, it was not an enforceable contract.
You basically used up your first portion, so if you still want your 3 minute of rebuttal, you probably need to yield the floor at this point.
I will yield to Mr. Fowler. Thank you, Your Honor.
Thank you. May it please the court. Let's just go to the reservation in the deed that allowed Delmar Seematter and Seematter Farms to purchase the property back. It is, in our view, a reservation. It was not a complete fee transfer, and that Colleen and Roger got the property with that limitation and that obligation to sell it back if there was a divorce or death. There is a question that Mr. Irvine pointed out about what Colleen knew. We believe that she knew about the deed. There's some evidence in the record, but that is disputed by Colleen. But the district court found that it was accepted, it was filed of record, and when the deed was accepted and filed of record, she accepted the benefit of the deed, if you will, and as a stop to deny the validity of the purchase agreement. And there is a lot of also evidence in the record about the purpose of the deed restriction, if you will, or the repurchase option. That is part of the record that is really uncontroverted, and that is that Delmar and Roger had conversations about it, and it was important to maintain the status of the farm and not have this one parcel in the middle of the farm go away from the family, and that's why the father agreed to transfer the land to the son and daughter-in-law with that restriction.
Doesn't the unusual fact that they started off with a deed that didn't have the repurchase provision, and then later the repurchase provision showed up in the final deed, doesn't that at least create a question of fact here as to what Colleen had notice of?
Well, no. There are some facts that color that. The deed was originally prepared without the reservation because they needed the bank needed a legal description. But the deed that was filed, which came about as a result of the discussion between Roger and his father Delmar, contained that language in it. And of course, filing a deed is a matter of record. That is why we have signed deeds. That prior document does not have an evidentiary value in determining the content of the deed itself that was filed.
So it's your position that I call it a repurchase provision, is no different than an easement or some other restrictive type covenant, that if it's in the deed and the deed gets filed, that's the end of the story?
Well, I think it is in this context, because it's not a conveyance of the complete uninhibited fee title to the land. You are given this land subject to, and this is a restriction in my view, subject to the fact that if a certain situation occurs, the grantor has the ability to claw back the property. And
that involves a conveyance of the property, back from Colleen to Delmar. And normally a conveyance of real estate needs to be in writing and signed by both parties, doesn't it?
Well, number one, it is in writing. filed of record in Marshall County. It is signed by, of course, Delmar and his wife. It is not signed by Colleen, but it was accepted and filed, and they took the benefit of that grant. And I believe that is sufficient, for example, to satisfy the statute of frauds. You have a writing, it is signed, it is accepted, it was performed upon, and that ought to be sufficient to allow the enforcement of what we think is this right to recover the property under the circumstances that the deed specified.
And then go ahead and proceed with the argument that even if this is a valid repurchase provision, its specific enforcement is barred by the homestead provision.
Well, it's not, because, and I think this is fairly clear, and we cite the Clark versus Axley case, among others, because the homestead, the deed gives them property subject to the restriction. The homestead does not exceed what they receive by virtue of the deed. And so in that context, there is no alienation of the property by Roger without his spouse's consent, because they got the property with the restriction on it. So the homestead does not expand the fee title of the property itself. It is what it is. So there is no conveyance of a homestead without the consent of the spouse. It doesn't apply.
Counsel, in that Clark v. Axley case, it was my understanding that the wife in that case actually signed the mortgage that was being foreclosed on. So she had, by signing the mortgage, consented to ultimately for it be foreclosed if the debt wasn't paid. And of course, that's one of the exceptions under the homestead law, foreclosure of property. So how do you get around that distinction between those facts and the ones that are before us?
Well, it has to do with the acceptance of the deed and the fact that deeds of record. Yes, so the signing of a mortgage is one way to avoid homestead protection from a lender to avoid the homestead protection. But in this context, we have, and it goes back to the point I just made a moment ago, we have a deed that was accepted by the parties, at least as a matter of law. While Colleen may deny the existence of the language, that it is filed a public record, they utilize the property and they accepted the deed. And we think that's enough. If that's not enough, maybe there's an issue there, but we think in this context, that is enough to allow the court to enforce the restriction that was found in the deed, which would be the restriction that allows the property to be purchased back. All right.
Yes, thank you.
If there aren't any more questions on that point, I want to go to the promissory estoppel argument. The plaintiff has cited the Boughton case a number of times and at great length. And I think it's important to recognize that this case is not the Boughton case. You first need to ask what is necessary to support a claim for promissory estoppel. And in order to get past summary judgment, you have to be able to show admissible evidence of a couple of things. First, there has to be admissible evidence of a promise. Then there has to be a detrimental reliance. And in this particular case, we have neither. The district court did a pretty good job of going through the facts and dicing out what the record showed in terms of the facts that lead up to this dispute. Roger Seematter was not the plaintiff in the Boughton case. There's no evidence that he forgoes some other career in any sort of meaningful way. There's evidence that he simply wanted to stay at the farm. There's a lot of evidence that he received benefits by staying at the farm. And there's no admissible evidence in this case of Delmer having told Roger as an inducement, if you stay here, I will give you the entire farm. And in fact, the evidence of Delmer's estate planning is quite to the contrary. He always wanted the farm to be in the Seematter family. And as we point out in the materials, he had estate planning in place many, many years, which had his other two sons sharing in the property and ultimately in a trust that would go to the grandkids. And that was always Delmar's intent all along. And the point is that the claim made by Colleen is that Delmer told Roger and Roger told me that this was the promise that was made. Well, except that Delmer says, I never made that promise. And Roger never said, at least in an evidentiary fashion that's admissible into court, that the promise was made. Unlike the Boughton case, where you had both of the parties to the alleged discussions that constitute the promises, both able to testify and have a fact finder weigh it. We don't have that here. And so under the hearsay statute, Colleen's suggestion of this promise is inherently unreliable and is not admissible. And so that's fact one. And the judge pointed out that the claim was based on layers of hearsay, speculation, and assumption. And I think that was very true. If you go back and look at the Rule 141 statements that are submitted in support of summary judgment, you will see that very little is truly controverted in this case. Colleen's would occasionally, as a matter of commentary on fact statements, would color it with her own version of the events, but the underlying facts are essentially uncontroverted, except for this notion of Colleen saying, well, Roger told me that the father made a promise, which is, of course, inadmissible. But then there's also a question of detrimental reliance. As I said, we have no evidence of changing in career choices or whatever you might have seen in the Boughton case at all. And there's nothing to suggest that Roger changed courses of action based on a purported promise that Delmer said, I'm going to give you all of this on my death. There's nothing there that would suggest that. There is an area of implausibility about the premise of the argument being made by Colleen, which is Delmer made a promise to Roger that Roger would get everything and that at the end, Delmer would leave his spouse, his other son, and his grandchildren without anything. So that's a fact that colors this case. But now let's look at what the promise is that Colleen says that she's trying to enforce. She's trying to enforce a promise that she will receive the property upon Delmer's death. And there has never been, even in Colleen's own evidence, any discussion of Colleen inheriting. When Colleen testified, and we quote her testimony at great length in our brief because it's important, she admitted that she was never present during any conversations where Delmer said that Roger was going to get all of the property or any of the property. And she admitted that she was not ever the subject of those kinds of statements by Delmer. And so that gets to a couple points. First of all, you have an evidentiary failure of the evidence. There's no way to submit the evidence of the promise because the elements or the evidence that they purport to offer is a hearsay under 60-460. But also there is no evidence that 18 years before Colleen married Roger, that Roger and Delmer entered into some sort of agreement that if you work here all my life, I will give you all this. And then the final point is a point that I think Judge Malone made right at the beginning of the oral argument in this case. Roger is now passed away, and that's unfortunate. But a key element of the claim being made here is that Roger would inherit, and Roger can no longer inherit. And that gets to the point of, I guess you would call it a frustration argument. But the law is clear that if you have in essence, a personal service kind of commitment, and the death of a person intervenes, then the obligation is excused. And we cite the Restatement of Contracts, Section 265, among that. So as authority for that. So we have a multiple layer of defense, if you will, to the claims being asserted by the plaintiff. We don't have evidence that's competent and admissible of the promise. We don't have evidence of detrimental reliance that goes back to cover the work history. We, in fact, in this case, don't have evidence that this is markedly unfair to Roger in terms of his work, because the evidence suggests that Roger shared in the benefits of the farming operation. And in fact, his father gifted him property, his father paid him profits. He allowed the purchase, he financed the purchase of land, leaving Roger with $1 million asset upon his death. So it's not a question of causing someone to become destitute or in a situation that's markedly unfair. And what we have is the evidence that the father all along wanted the property to remain in the family. And that is consistent, I think, with the testimony that has been provided to the judge. So this is not the Bolton case at all. And so then finally we get to the notion of unjust enrichment, which is the point that Mr. Irvine made as well. And this case, again, is different than Bolton, because in Bolton, the claim wasn't for the value of the farm that the professor thought she was going to get. It was for the economic loss caused by her reliance on the promise, which was measured by her lost income as a law professor that she had foregone in reliance to the promise. Here we have no evidence whatsoever to establish any amount to show how much Delmer or his company was unjustly enriched. We asked those questions, and they said they couldn't even guess. They could not give us an amount. So that is another reason why an unjust enrichment claim fails, because there is a burden upon the plaintiff in the case to show what it is you claim was the unjust enrichment. And they chose to offer no evidence. Instead, they argued for the entire value of Delmer's property. And that would not be the proper measure of damages for an unjust enrichment case. So those are the main points. Procedurally, the court could have granted our summary judgment because of what I would call the failures under Rule 141. The district court set that aside and went to the merits, and in going to the merits, made the fundamental determination that you have to have admissible evidence to support a promise, that the evidence offered did not support that premise, and that even if there was evidence that was admissible, the promise being made is not the promise sought to be enforced, which is that Colleen now wants to inherit, and that was never part of any deal. Any questions?
Apparently not, counsel. Thank you. Mr. Irvine, you still have your 3 minutes of rebuttal.
Please, the court. The defendant, Mr. Fowler, in his brief, as well as in his argument today, attempts to downplay the importance of that first deed. And in his brief, he goes so far as to say, quote, "This document was given to the bank for the sole purpose of furnishing a legal description of the property." And I guess that begs the question, if all the bank needed was a legal description, then why was an entire deed prepared without the option contract in it? It just makes no sense. The legal description was just a small part of that first deed. In all other aspects, that deed was a complete deed in and of itself. with the sole exclusion of that option contract. And then I guess I'd like to get back to the homestead argument just a little bit. And the homestead provisions in the law are very strong, and they protect a residence that's occupied by a family. They protect a home that's occupied by a family as their residence, which is the case in this instance. And the Kansas Constitution provides that there are only 3 exceptions to that rule, which is number 1, non-payment of taxes, which is non-applicable. Number 2, payment of obligations for the purchase of the property, which gets back to the Clark v. Axley case that was cited by the defendant in support of their position. And as Judge McEnany points out, there was a mortgage signed by the wife in that case, which there is no such signature in this one. And then the third one is for the payment of obligations for improvements of the property, none of which are applicable. So that's why our position is that the homestead applies in this circumstance. And then you combine that with the statute of frauds, and then the other statute that I cite, which ties them all together, which is 60-2303. It requires the wife's signature to convey real estate that's occupied by her as her homestead. And we believe that fails in this case, and the district court judge erred when they failed to recognize that point. And I'd like to address one more point, and then I'll conclude. And that is the public notice statute that was also addressed by Judge McEnany earlier in this argument. And there is Kansas case law that supports the proposition that that notice statute is not always absolute. And the Jeremiah case that I cite it supports that proposition. And in that case, they said the notice statute was not sufficient to put the grantees on notice. So for those reasons, we believe that the district court in Marshall County erred in granting summary judgment on the defendant's motion, and we ask that you reverse it and remand it with directions. Thank you.
All right, counsel, thank you very much for your briefs and your arguments. Very interesting case. With that concludes this morning's hearings. Thank you.